Yes.
And they had begun by saying that the court has grasped with clarity the positions in this file and deemed it fit that it needs to go and acquaint itself sufficiently. One thing, Your Ladyship, that has not been mentioned before you is that petition number 7 was from Machakos. It was transmitted to the principal judge with a date for 22nd of April for a mention. But in the wisdom of the principal judge, he issued us with a notice that the matter was then brought forward to the 9th. And on 9th, Your Ladyship, further orders were issued by the principal judge that the matter be mentioned before you to date. And we take note, Your Ladyship, that the file is not before the court. While we were before the principal judge directed that that file be mentioned along other files. There were no orders of consolidation. We challenged the court to tell us the status of the orders that had been issued in Machakos, the orders of status quo, noting that the application was then supposed to be mentioned on 22nd, but then brought forward to 9th and then to date.
So you inquired on what? On the status of the orders?
Yes, the status quo order that were granted. The purpose why we challenged the court was that in our thinking that the orders generally do lapse on the date the matter appears before the court. So to date, there are two things that have transpired. One, the file is not before you. And the date for appearance before the court is the 12th of April. Our interpretation is that there cannot be orders that can be extended. As sought by my lord and senior Mr. Kisii. And that upon the arrival of the date to appear before Your Ladyship and the absence of the file, then Your Ladyship, the court's hands are tied. Number 2, Your Ladyship, is that the other file that had orders was the petition number 1, which neither me nor Mr. Kisii have audience because we have not been enjoined. We have not been enjoined to that proceedings. The only person who can seek the extension of his orders, if he so wishes, is my learned senior Mr. Munyalo Muli. Mr. Munyalo Muli is the one who knew why he sought the orders. If he needs to sustain them, if he doesn't need to sustain them, that's up to him. But from the bar where we sit, myself and Mr. Kisii, we have no capacity to urge this court to take any further step. Insofar as petition number 1 is in issue, until the date we are going to be enjoined, and until the date the withdrawal is determined. Finally, Your Ladyship, as well captioned by my learned senior Mr. Deuri, before I invite Mr. Monda just to make a remark, is that we are seriously constrained to say and to state that the principal judge exceeded his mandate under Section 6 of the High Court Organization and Administration Act.
Mandate under?
Section 2 and Section 6 of the High Court Organization and Administration Act, Cap 8C. We are further constrained to say that the orders of consolidation being addressed by my learned senior Mr. Kato Kigen, in light of the sections I have quoted, may not be well fitting, but we shall address that because this court is still possessed with sufficient jurisdiction to put the orders or the records into proper perspective, because it's a court of concurrent jurisdiction. Noting that whatever I am raising is not an address seeking to appeal, but seeking to bring to the attention of the court the anomaly. And it's a legal anomaly that is a statutory in nature, which the court can rectify the records.